on negotiation and presentation mastery. And today we're particularly looking at the art of winning pitches, maximizing margins, and drafting airtight deals. And as you know, most of us in the legal profession really leverage on these skills to earn a living on a day to day in a world that is having an evolving legal landscape. And this afternoon, we are privileged to have a very distinguished panel of titans that have really distinguished themselves in this field of corporate practice. And they'll be sharing with us the different perspectives on this art of negotiation and presentation. How should you brand yourself? How should you draft airtight deals? And how should you negotiate? And so we are privileged to be joined by a very distinguished panel of eminent ladies and gentlemen who will be expertly moderated by Miss Elizabeth Musikali, who is a lecturer at the Catholic University, but also chairperson of our corporate law committee. Elizabeth, we are really happy to have you once again. And you take us on now for the next 2 hours, and we are glad. Thank you.
Right. Thank you very much, Gabriel. Good afternoon, everyone. It's my great pleasure to welcome you to today's session on negotiation fundamentals, maximizing margins without burning bridges. As you've heard, I'm Elizabeth Musikali. I'm an advocate of the High Court of Kenya, and as well, I'm a lecturer of law at the Catholic University of Eastern Africa, as well as a chairperson of the corporate committee, law committee at the ELS Society. Now, I'm going to take us through today's session with a few of our distinguished panelists today. But first, I'll introduce the session where we'll be discussing how to win pitches, maximize margins, and draft airtight deals. Now, in the legal profession today, technical expertise alone no longer guarantees success. Mastery of negotiation and presentation has become a defining competitive edge. And the 2024 Clio Legal Trends Report indicates that 75% of law firms attribute client acquisition and retention to superior communication and persuasion skills. Also, we have a Thomson Reuters survey from the same year, which notes that 68% of corporate clients prioritize lawyers who can negotiate favorable terms efficiently. As global markets tighten and client expectations evolve, the ability to win pitches, maximize profitability, and secure airtight agreements is paramount. So this is very critical in an era where legal services are increasingly commoditized, and AI tools such as contract analysis platforms are shifting the focus from more routine drafting to high-stakes interpersonal engagement. So this session is designed to equip us with the advanced skills needed to excel in these pivotal areas. And to take us through today's session, we have 4 distinguished panelists. I'll introduce them, and then we'll get into the discussion. First, we have with us Mr. Sunday Godfrey Damugoba, who is a partner at Rive & Company, where he heads the IP and technology department. He has a decade of experience in corporate and commercial law, and he specializes in IP, data protection, tech law, arbitration, and regulatory compliance, advising clients across Tanzania and Zanzibar. So he's also an advocate of the High Court of Tanzania and Zanzibar, and a thought leader at the intersection of technology, IP, ethics, finance, and law, with a focus on privacy, AI governance, and digital accountability. Additionally, he chairs the IP committee at the ELS Society and serves on the Global Advisory Council for the International Trademark Association. Karibu, Mr. Damugoba.
Asante sana.
Additionally, we have Ms. Asmahani Saad, who's an advocate and a legal consultant and an alternative dispute resolution practitioner who specializes in corporate and commercial law projects and ADR. She's also a committee member of First Ever Appointed Investment Advisory committee that advises the Minister of Finance, Planning and Economic Development on the Petroleum Revenue Investment Reserve Fund, and a non-executive director to the board of the United Bank of Africa in Uganda. She's also a board trustee to the board of Greater Tomorrow African Initiative, which is a not-for-profit organization, and the Secretary General to the Governing Council of the East Africa Law Society. Karibu, Ms. Saad. We also have with us Dr. Habimana.
And Secretary
P.
General is emeritus. I don't want current Secretary General to think I'm emeritus.
That's noted.
Yes.
Right. So we also have with us Dr. P. Habimana, who's a visionary Rwandan academic and an arbitrator and corporate lawyer with a career spanning over 16 years, with expertise in tax law, arbitration, corporate governance, ethics, compliance, and transactions. And he's the founding partner of Amilex Chambers and currently serves as a senior lecturer and vice dean at the University of Rwanda School of Law. Additionally, he serves as a non-executive director at the Bank of Kigali PLC, which is the largest financial institution in Rwanda, and as a chairman of the Multi-Sector Investment Group PLC. His leadership legacy includes various roles as vice president of the East Africa Law Society, a director at Coke Bank PLC. I apologize for massacring the name, and Pinterest Limited, and he's a member of the governing council of the Rwanda Bar Association. Karibu, Dr. Habimana.
Elizabeth, asante sana.
You're welcome. Now I'll start with you, Dr. Habimana. From your experience of giving pitches, what differentiates a good pitch from a great one in the legal or corporate world?
Yeah, Elizabeth, thank you so much for that good one. Good question, by the way. So indeed, it all starts by understanding what's the difference between what is good and what is great. I think I'm audible. Okay, yeah, good. So now, most of the time, there's a lot of discussion on how to distinguish what is good and what is great. But when I'm talking to lawyers, I like to say that being a lawyer itself, it is good. And every lawyer is supposed by nature, once a person is a lawyer, by nature that person is good. So now what is the task? The task is to upgrade from being good to becoming great. And why not to becoming excellent and perfect? Something like that. So same question is about how to make sure that there is a great pitch from a good pitch, because any pitch can be good. So now in the corporate issues, in the corporate matters, lawyers, when we are at the school, either at the university or in practice law schools, we are taught of doing our things either in drafting, either in communicating, everything you do, they tell us you have to ensure that you have clarity, you have precision, etc. So that is a normal preaching for any legal training. So that is good. Having something which is clear, which is precise, that is good. And information which is clear, that is a good information. But in a corporate matters, a pitch to be considered as a great, it has to go beyond that clarity, beyond that precision, and have a nature of a strategic pitch. So beyond the clarity, we need to have pitch which is strategic, which is addressing the client's pain points, and which can inform the client to take a strategic decision. And understandable, of course, a strategic decision is not the same as a decision. Any person can take a decision, but not any person can take a strategic decision. So in a few words, I think in corporate matters, our clients are very strategic, and being in a negotiation, being in discussion, being in communication, lawyers, we have to consider that aspect of adding a strategic value. As a lawyer, you can propose a business value for a client, but that is normal for a corporate client. Anything done by a business person is always looking for a business value. Now, how can a lawyer add a kind of a competitive advantage? For me, that is what I can consider as being great from being good. And for this to happen, as a lawyer, we need to position ourselves in the mind of our client so that we can understand what is the strategic interest of the client, so that you can think which strategic value we can add. So how our client can gain a value, a strategic value added by a lawyer. So in a brief, that's what I think that can be considered as distinguishing great from being good.
Yes, thank you so much, Mr. Habimana. And Mr. Ndamugoba, when it comes to drafting airtight deals, what are the hallmarks of an airtight contract in today's fast-evolving commercial landscape?
So, thank you. Let me turn my video on. Ah, brilliant. Thank you. So, when it comes to an airtight contract, I will give you from a Tanzanian perspective. So, because in today's dynamic commercial environment, particularly here in Tanzania, an airtight contract is distinguished by several hallmarks. One, I would say, having quality and precision. So the language has to be very clear, precise, and free of any ambiguity. So every party's rights, let's say responsibilities, their deliverables, timeline, payment terms have to be very well defined. And this is especially very vital example, because let's say Tanzania, we speak English and Swahili, but for us to be able to deliver, let's say, to serve our clients well, or as lawyer to be able to have something that is, I would say, very easy to understand when it comes to contracts. You have to make sure that we have a language that is very commercial, but has a great understanding to the other party. But also, I feel that you also need to consider comprehensive coverage. So the contract must be exhaustive when you anticipate and when you're addressing potential contingencies, for example. So it includes clauses such as breach, the remedies, termination, dispute resolution, and you have to be thorough when you to look at especially on the what ifs, what will happen, but also on clearly defined terms. So it's critical so the terms are defined within the contract. I believe it's very key. So we look at, let's say, what is a material breach, and if they are very clearly defined, it's easy now to prevent any future misunderstanding. But also you have to have strategic risk allocation, where now that also will assist you when you're drafting a contract to have and for you to be able to have an airtight contract. It doesn't shy away from identifying potential risks. So a clear and fairly allocation of responsibility for those for the risk between parties is very prime, I believe. So that means you have to have a well thought out limitation of liability, for example, indemnity, force majeure clauses, of which considers local Tanzania realities, for example, such as, let's say, infrastructure challenges, specific regulatory landscapes, but it has to be fully compliant with the law. Like the Tanzanian law, the contract law must be unequivocally compliant with the government laws. This means, for example, our Law Contract Act of CAP 345, revised edition of 2019, but also other relevant sector legislations, for instance, the mining, telecommunications, land transaction, or banking. So the governing law of the contract itself should be very explicitly stated. And the enforceability element as well. So every provision must be legally sound and enforceable with the legal framework, let's say in Tanzania, courts, or the alternative, whether it be LCIA or the likes. But clause that they should be the ones that do not contravene, for example, the public policy and statutory prohibitions under the law. And also, I always emphasize on clear dispute resolution mechanism. So the contract should have an outline of practical, efficient, and I would say clear mechanism for resolving disputes. This could range from a lot of things, let's say from negotiation to mediation, perhaps let's say through like Tanzania Institute of Arbitrators in Tanzania, then to arbitration or to court. So the choice should really reflect the nature of the contract, what the parties need, and you look at the proper execution so that to ensure that you have it's valid. So they have to be executed correctly. So you include proper signing, attestation, campus seal, and the likes. I feel that is like a fundamental step, and sometimes it's overlooked. But also, we need to also look at adaptability. So while you aim for an airtight modern contracts, especially long-term ones, you may benefit from built-in mechanisms for controlled adoption of, let's say, unforeseen changes, such as credit-defined order. Let's say there is an order processes or review clauses without missing or going into contest in renegotiation. So I would say it's very important to do those, so that for you to be able to have like an airtight contract, but a contract that is well written and encompasses everything that is needed. So it adds to more of not just quality, but some that is very, very enforceable, but that you can actually now say, if there was anything to happen in the future, my contract, in as far as a contract is concerned, a properly written contract, you are done with your offers, your acceptance, your legal obligations is there, and you have all the terms are in place, then I believe these are the key things that you have to consider. So for now, I'll end up there, and I'll give it back to you.
Thank you very much, Mr. Sunday, for that. And now when you talk about the fundamentals of negotiation, Ms. Sad, what are the foundational principles which should guide any successful legal negotiation? But before even we proceed, we'd like to take note of our new panelist, Mr. Modest Mulumba, who is, Dr. Modest Mulumba, who is a managing partner and founder at Modest Mulumba Law Firm and a lecturer at Kalembe University in DRC. Karibu sana. We go back to Ms. Sad, and we are still on negotiation fundamentals, and we're talking about the foundational principles. Which are these foundational principles that guide a successful legal negotiation?
All right, thank you, Elizabeth. Good afternoon to you all members. Thank you for joining this very, very seasoned and important discussion. So foundations of a successful negotiation. I may want to look at it in twofold. Perhaps where you are negotiating in a representative capacity, you have been appointed or instructed by your client to negotiate on their behalf. And then briefly, I'll just maybe hint on how these negotiations skills can again be applied to us in our day-to-day lives when you're negotiating for fees, negotiating with your employees, because negotiation is part of life. This morning, I was negotiating with my sons because they want to go to swim. It's part of their school curriculum, and for some reason, we had to have a brief negotiation. And of course, sometimes depending on the needs or what position you're coming with, I had the power play position. I'm the mom, and sometimes what mommy says goes, so they had to abide, and we ended that discussion there. So just to debunk negotiation, it's our daily life. It's our daily life. We negotiate every time. We negotiate with ourselves. When we want to do some things, we want to make certain decisions, there will be that distinctive need for a negotiation, right, wrong, take a decision or notes, or just to debunk the whole aspect of negotiation. But specifically to this topic, legal negotiations, your client approaches you, they are going through or they want to handle a contract and transaction, whatever perspective they have, and they want you as their appointed attorney to lead or to guide these negotiations. First and foremost, I think that understanding has to be very, very clear in what capacity you're stepping into these negotiations. Coming from a mediator's background, I used to mediate at the commercial court, and part of what we used to do is negotiate matters before they can go for litigation. And sometimes the way lawyers would handle these negotiations, they wouldn't even want their clients to speak. and with mediation, it's more of a very party-based kind of negotiation. You want to hear the actual parties. You want to hear, yes, you have been appointed, but what are the deeper issues around this matter that maybe perhaps you as a lawyer, you didn't get to understand. So for me, every time I get such instructions, I really want to wear that hat, that I am a representative. At some point in time, I will, if I'm with my client, I will want also them to talk about certain issues that I may not have perceived very well. And I'm here as your representative, perhaps my expertise in terms of understanding key aspects of the transaction, but I don't know your innermost need, what is driving you to get into this negotiation. So I'll start with that. As lawyers, we need to have that heart, that space, that room to know that you're acting in a representative capacity. Your client should be given a chance at any one point in time, should they want to also participate in this negotiation. Then secondly, you have to prepare. You have to prepare. I have found this to be very, very, very important, yet sometimes it's what we forget. We sometimes forget to do this. Why? Because certain transactions are, they're our usual business, their usual way of life. Someone comes and says, I want you to negotiate a contract for me. Yeah, I don't know how many contracts I've negotiated in my lifetime, my 16 or so years in practice. So I might just take it for granted and want to walk in there, but believe me, you are already leading yourself to a pit that you don't want to get into. So take some time, prepare, understand, however small the value is, however big the value is, but give your client that opportunity that you, as their representative, you will prepare, you understand the issues, you understand what are the negotiation points, what are the pain points, what are the interests, what are the needs, what is the sector. There's so many things that can be carried through there that sometimes we can just forget. So preparation is very key. Then the other aspect I'll talk about, if you're acting in a representative capacity, is distinguish between the needs and the wants, right? This is very important. And you can just do a little matrix. I always draw in my diary when I'm going through these. After understanding, we've had a discussion with my client, we've talked about these things. Sometimes people present a lot of wants. I want this, I will not, I want them to give me there must be an interest in case things default. I want this, yes, it's good to want. But in there, you understand what are the most critical aspects of this negotiation, and those are the needs. What does the client need? Is this a long-term contract? If you're running a long contract, then for me, your need is to build a relationship within this transaction. It's not a one-off. So in as much as you want all these things, liquidated damages, what, I have understood that it's a long-term contract. There is a need that you have not identified. So mine is to see that as we structure this contract, as we structure this transaction, is there room for flexibility? Is there room, if there is any form of dispute or anything, is there room for us to sit down on the table and put our relationship first before everything else? So that's just an example of how you can clearly distinguish between the needs and the wants. And that is also very important. Then, fourthly, go with options. A life without options is a very, it's a bad life. I always say this. have options, have options. Present options, even as you're having these first, second, third discussions with your client, depending on the timelines you have. Think about options. That's where creativity comes in. Have what ifs. What if, what if, what if? Because if you go with a one-minded position, you don't know how the other party is going to respond or react. Because some people in negotiations, they're either responsive or they're reactive. Now, if you're dealing with a party who is reactive and all you've come with one position, you are due to fail. So your client might not see it your way, but always in your questions, formulate questions that can narrow down options so that when you hit a dead end, when you hit some kind of impasse, it's quick for you as a client, a negotiating client, a good negotiator to always have options. And then you can drop in our TIF. What if we look at it this way? What if we look at it this way? Every time people hear options, there's a way it debunks the perceptions that people have come with. It debunks fears because it's like you're telling them what's the worst that can happen. And once they have that and it's very clear, then you can easily you can continue your negotiations, especially when you hit those impasse moments. Fifth, and this is just as in representative capacity, interests. What does your client want? What is his interest? What are those things? Like, don't go into a negotiation and you're making demands. Human beings, you're dealing with a fellow human beings. No one wants to be told what to do. No one wants to be told how to do. Sometimes you're dealing with someone, even if it's an international client, they have been in this business for years and years. And here you are from my Uganda little jurisdiction. It's a international trade transaction. And I'm there making demands. When you're bringing our goods to Uganda, and the person is just looking at you and they're like, my one day sales can buy and sell your company in a minute. So always come with this position. It's always good to fully understand also the other party. Do some research. Don't jump into negotiations without at least having an understanding of who am I talking to, who am I meeting, who am I going to face, because it empowers you. And sometimes, like I said, yes, your client is there. Sometimes clients can mislead us, right? And so for you to empower yourself, you also need to understand the other party from your own perspective. And then, of course, you also hear what the client has to say. Then I will just now kind of branch it into our daily legal lives as lawyers. We negotiate a lot with our clients. We negotiate fees. We negotiate in our businesses, with our teams and all this. But maybe just to give it a perspective for purposes of this webinar, I'll just talk about maybe fees, the business of things as clients. It's also important that these same principles, you mirror them into how you run your business, how you attract clients to you. I mean, we are living in a world where I think these days even AI can negotiate for you. I'm yet to think that people can drop in some things in ChatGPT or whichever AI, and it can tell them some things that sometimes they look at you as a lawyer and they're like, I don't see any value you're giving me, other than maybe just sign and put a stamp or something, because that's what is required of this transaction to be sealed. But I think we always we have moved from that kind of practice where people come to you because you're Smahani Sad, you're the best in this, you have all this knowledge. No, now it's more about relationships. It's more about value on top of the knowledge that you know, which I think everyone now can get anywhere. We are living in a knowledge, information-based world. What else can I get from you? So those things are important. If it's your social networks, be open. Other than me incorporating your company, am I able to push some licenses for you because I know this? Like, don't be ashamed to talk about those things. Other than me doing this for you, there is more value that I can offer you. I mean, we represent so many banks in Uganda, but these days when we are doing market entry clients, we always position ourselves as those firms who can get our bank clients, if you know what I mean. So we say, I also have a bank that I will, throw in there. And then I tell the CS, whoever I'm dealing with, by the way, I have these clients who are doing market entry. They're in trade, they're in whatever, they are setting up a project. I am referring them to your bank to open up an account. So on this side, the client is saying, okay, okay, I have, yeah. And then also the bank is saying, okay, these are good lawyers to have. They are giving us business. So I think let me leave it at that. I could go on and on. I love negotiation. I'm a negotiator. I'm a mediator. So this, I could go on and on, but let me end it there, Elizabeth, and I'll have the follow-up questions. Thank you.
Thank you so much for that, Asmahani. That was very informative. And still on negotiations, I'll take it to Modest. What makes a negotiation high stake? What makes a negotiation high stakes, and how should legal professionals adjust their approach when the stakes are elevated?
Thank you. Thank you, Elizabeth. Good afternoon, ladies and gentlemen. I'm very happy to join this panel in order to share my experience as a lawyer. And you asked me to answer what makes negotiation high stake and how should legal professionals adjust their approach when the stakes are elevated. The main problem in the negotiation is like Atney come to say now. We have to be free in your mind in order to push the parties to get the resolution. You see, the negotiation is one of the alternative dispute resolution in which we can't go to the court in order to get solution. And for this alternative dispute resolution, we have first value to understand the negotiation process. We have to get the importance of preparation in negotiation. We have to establish goals and limitation. We have to get communication clearly to get what you want. And in this process, like Atney come to say, there are many needs and wants. If you have to make the balance among the needs and the want, you will have and find a solution which can make negotiation high stake and help the legal profession to adjust the approach. Is what I can say in short.
Thank you so much. I'll go back to Dr. Habimana. Now, when it comes to making a pitch, how important is storytelling in legal presentations? And what structure or elements make a narrative compelling? How important is storytelling?
Yes, Elizabeth, thank you so much. It is very important. It is very crucial because it is through storytelling that person can transform the complex legal arguments into simple, engaging, and persuasive narratives. So, we lawyers, sometimes when we are dealing with non-lawyers, we have that practice of using complex legal terms, complex legal principles, theories, yet you are telling to non-lawyers who don't know those theories and the principles and the complex concept. So then through storytelling, you can put your client in a situation of easily understanding what is initially complex for your client who may not be a non-lawyer or for the other party, depending on in the context where you are. And another relevance of storytelling is that it improves retention for your audience, because psychologically, people can remember the stories more than they can remember the fact. A person can sit in a session for 2 or 3 hours. He may go back without having an idea of what has been discussed in the session, but can go back with a good mind of one story that has been shared. in that session. So once you want your audience not to forget what you've been saying, you better use that method of storytelling. And also, storytelling can be used to humanize legal issues. Because storytelling can be used to bring abstract legal concept into a real world life. So it can be a good method to link the theories to the practice. And every time, it's not necessary to use a storytelling because it may depend on the context of the setting. But there exist some other alternatives. You may not use storytelling. You can use the figures. You can use data. You can use charts. You can use diagrams, etc. So depending on the context, of course. And I know several lawyers, they say they are not good in mathematics. So when you say you can use the figures and the numbers and data, they can think, wow, we have gone to law school because we're not good in the sciences, we're not good in mathematics. Yes, I agree and I understand. But again, that is one of the way a lawyer can distinguish himself or herself as an excellent lawyer. Because it's a matter of getting out of the crowd. And again, if a person is not good in mathematics, at least that person can be good in numbers. It's not about pure mathematics. It's just about numbers. You can present your figures. You say, these are the numbers. That is a good way, especially at the beginning. That is a good way to call attention of your audience when you are using numbers, data, figures, storytelling, etc. And so back to you, Elizabeth.
Thank you very much, Dr. Habimana. I'd like to encourage the participants to ask questions in the chat box or even use the Q&A section. And at the end of the session, we're going to have our panelists address some of the questions that you have. Now, back to Mr. Sunday. With regards to contract design, or rather modern contract design, how can we as lawyers ensure clarity in legal drafting and accessibility without compromising the legal robustness? Because again, we're dealing with clients who might not be aware of legal terminologies or the legal requirements.
So thank you, Elizabeth. So I agree with you. In my 14 years plus in legal practice, I've encountered a lot, especially when it comes to drafting. So, and most clients on how they deal with how we present our contracts or how we present our robustness and how we can now draft it well, make sure that it's very clear, but then we don't compromise, has been pivotal. So speaking from the Tanzanian context, for achieving both clarity and for accessibility and having an uncompromised legal robustness, I believe that is very core. One, I think you need to champion for plain language. So while legal precision is essential, we need to always avoid unnecessary jargons. Overly complex sentences and structures don't go well. So we're using plain English language makes the contract more accessible. And in certain contexts, like in Tanzania, providing a Swahili maybe summary or explanation of like key complex clauses can enhance understanding for the clients. And even if it's an official contract language, remain English, but still we have to do so. And then there's logical and intuitive structure. So a well-organized contract that is very clear, it's logical, except for headings, subheadings, and perhaps for those longer documents. At times we even see on how we can break it down so that you aid readability, and then you embrace also what to, if you when I teach you English, they'll tell you of active voice and passive voice and directiveness. So that use of active voice, like a party shall, is generally clearer and more direct than the passive voice. So stating obligations as well directly leaves less room for interpretation. And like I said the first time when you asked me the first question, for clarity and drafting, it is always best also to define terms. So a dedicated section for definitions section, I believe, is non-negotiable. So defining crucial terms upfront is very, very important throughout the document. So there is consistency, like when they look at the definition part, they see its consistency it's throughout the document. It's the same. If you define terms, those terms should always be used consistently within the document. Also, I think we call relentless pursuing of an ambiguity. So I feel like we need to scrutinize every clause. So ask yourself, could this be interpreted in more than one way? So this self-review is very vital, but also to maintain consistency, like I said, using the same term throughout the whole document for consistency, but also consciousness, like having shorter sentences and paragraph are generally easier to understand, so that complex ideas can be very well broken down. And strategical use of annexures and schedules for detailed technical explanations or specifications, complex calculations or extensive lists. Using annexures makes the main body clearer and cleaner and focus, so improves readability. Also, I always tell my team the value of fresh pair of eyes. So I always encourage to have another person, a colleague, to look at the ambiguities, clarifications, and the likes. It's very, very important to do that. But always never compromise on legal essentials. So you need to, let's say, for all essentials of a valid contract in Tanzania, offer acceptance, consideration, intention to create legal relations, capacity, legality, all those ones have to be present. We normally forget that, but it's very important. But I feel like for a robust, boilerplate clauses such as the entire agreement, waivers, severability, notices, governing law, dispute resolution, remain vital for a contract integrity and enforceability. So I'll say for more clarity on drafting, it's very important to adhere to those so that it's very clear. It's very, very clear if you take through what I've just said. I'll end up there.
Thank you very much, Mr. Sunday. We'll come back to you on that. Now, still going on with the discussion on negotiation. Ms. Sad, how can legal practitioners negotiate assertively? How can we be assertive while still preserving long-term client and counterparty relationships?
Sorry, my mic was muted. Can you hear me? Yeah. So legal practitioners, assertiveness. I think there is room for assertiveness. Assertiveness really, in simple English or in simple, my understanding, minus the definition, the dictionary and what, it's just you having a position that you can clearly communicate. But I think the line in assertiveness is drawn when you lose the objectivity and it becomes emotional. So most times people interpret assertiveness to be an emotional act. You're acting out of, you've left objectivity and now you have a position that you have to bring forward, win or lose. It eventually becomes that it quickly manifests into the win or lose kind of position. But we live in a world where we now realize the win-win kind of situation is always best. It's good for people to win, yes. But I know even these days in schools, whenever, even in races, they always say this was the first, then they say, but also the other winners, then they will celebrate the second, the third, and fourth. So that's the world we live in. It creates harmony. It allows people to have psychological safety to say certain things when they know that we are not looking out for a winner or loser. So assertiveness is something that I have found is, I don't know whether intentionally or unintentionally, or because legal training then was more of, we have to get into a litigious kind of situation. There always has to be a winner and a loser. And I think that mindset context eventually is mimicked into, I will say, transactional world. And I'll speak with this because my practice is more of commercial transactional practice and ADR. And so people come with that mindset. It's okay, like I said, to be assertive, but you have to know where the line is drawn. Where are you moving from the assertiveness that, yes, I have come with a point, like everyone, you've interpreted your law, whichever side you are, you want to make that point come out. But where does it move and it becomes an emotional position? It becomes emotional position. So you move from wanting to build trust to asserting yourself, to have demands, you want your results, you want only your way. So assertiveness can come to that extent where it's either my way or no way. I have been in rooms where lawyers have made it clear, either it's this position or this deal is done. And you're like, okay, really? So I think for me, it starts with the mindset change. We need to know that the world we live in now, it's a win-win world. It's a global world. It's a world where today I'm seated here. I don't know how many people on call who are not even in Uganda or all these jurisdictions, and we are here together trying to formulate one mind. So it starts from there. It's the mind. We have to make some serious mind shifts. And I always talk to this when I'm talking to people who are very litigious in practice and in the kind of the way they relate. I always tell trial or litigious lawyers that even in court, and now I see more and more judges and the way courts have started embracing, everyone wants a position where you can come to a middle ground. I mean, even now in Uganda recently, the Court of Appeal has embraced mediation and, even up to Supreme Court. So there is that mindset. We are evolving. We want to have that flexibility. So yes, we can be assertive as lawyers, but we need to understand the extent of our assertiveness. And I know because sometimes we are so involved in our clients' issues, our clients' positions, they are our clients. They are our clients. They are our people. So I think that when you have that mindset, then you need to know, okay, how I'm becoming emotional about this issue. Can I take a break? It's always okay. I mean, me, I sometimes really, I can feel myself that, okay, this issue, I'm like, oh my God, like I'm boiling on behalf of my client. But because of the continuous practice and my mindset change, I always have those moments where I ask the other counsel, I'm like, you know what, can we take a break? Can we take a breather? And it's okay. I mean, that is the golden moment in negotiations, when you can be able to call it out and say, let's take a breather. Everyone, let's break. Or you can even come back the next day, whatever you have to do to maintain your empathy, to maintain your humane, to maintain the purpose of the negotiation, that we are here to win-win. No one wants anyone to lose. So when you move from that, then you become that kind of negotiator who is looking at relationships. Like I said, relationships are very, very important, very important. And even as we are negotiating, for me, I've come to a place where I always open my clients to the mind that you will quarrel in this relationship. There will be disputes. There is not perfect transaction. I am yet to witness one. And I don't know if anyone in this room has witnessed one. Please put your hand up and tell me that there is, whether it's banking, whether it's international trade, I have not seen a perfect transaction. Why? We are transacting as imperfect humans. We are transacting in a world of relationships. We are transacting in a world of perceptions, biases, whatever it is. Something small can start small, maybe just the way someone talked to someone. Or Asmahani came in and she looked at me up and down, and the other person on the other group, maybe it's a female, and she's like, Kali, this chick, eh? And immediately the thing just starts quickly turning around so easily. So because of that, we need to be open to talk about disputes. When we quarrel, and me this even said disputes, when we quarrel or when we miscommunicate and misunderstand and whatever happens, how are we going to deal with this situation? So you demystify it. So even when it happens, there's no fear around it. You say, okay, there was a miscommunication, the notice came out of time. Does this mean that it's do or die, this transaction is ending today, given all that we have put in? No. Can we have some flexibility? What can we do about it? Those are the options I talked about. Then quickly, you get back into the goal, the purpose of this transaction. So that kind of approach, it's more empathetic, it's more attached to the scenario, the situation they're in. And it's always a kind of mindset that wants to continuously move the transaction forward. So you can be firm, that's fine. It's very good to come when you're firm. People respect that, but also show that there is some flexibility. Your position is not the only one. It's not my way or the highway. No. What are the options? How can we work around this issue that we are not able to solve now? Then also it encourages collaboration. We all know that we are living in a world that being in silos, working alone no longer works, you know? Now, today I might sit with Elizabeth. She's the opposite counsel in the other transaction. I'm here. But when I enter that room and I think that, oh, I'll never see Elizabeth again. Let me come and show her. This is it. I mean, things don't work like that. I will step out of that room. I never know which the next client will come, and she will be the same person in the other room. So we also have to have that global collaborative mindset. Yes, I'm here to represent my client. I know my position. I'm nowhere going to be compromised. But at the end of the day, what we need out of these are good relationships. And from those good relationships, you find that I can even be able to call Elizabeth at midnight. Now, because there's a sticky issue and I'm like, okay, can I do this? But because you have come out of that room with a friendlier approach, with a more relational approach, I'm sure I should pick my call. But if I came with this thing of, man, I am the one who knows, you lawyers don't know anything, I kid you not, Elizabeth, just know, would you pick up my call at midnight? I wouldn't even want to hear from you So the collaboration, the relationships, the trust, the needs I talked about, the values, even your clients, you don't want them to be the one-off. You want them to come back, and they see these things come out as you continuously participate in either engaging with them or representing them. Yeah. Back to you, Elizabeth. I'll end it at there.
Right. Thank you so much for that. Now, because negotiations are usually high pressure situations, Modest, what are the key mental habits or routines that help professionals maintain confidence during negotiations or presentations?
Yes. Can you remember again?
Right. So I'm asking because we are talking about negotiations, which are high pressure situations. What are the key mental habits or routines that we as professionals can use to maintain confidence during negotiations or presentations?
Okay. The main part of negotiation, you have to be neutral, and to take the wishes and the want of each party before giving the resolution. And in the classic way to give the good negotiation, you have in the first step, the negotiation must be processed in order to ensure that everyone is ready to the actual negotiation. Before you begin negotiation, or thought to step in your mind of what you are going to do. And the second step, you have to be open. By opening the stage of the process, you will identify your needs with the other party. After identification of the needs with the other party, we will exchange the views. After exchanging the views with some people, can refer to this and arguing the stage. After that stage, we'll explore the stage. Usually, if there's no agreement, you'll try to approach both of the sides in established what they want and not they can both move forward to reach an agreement. After that step, we'll have to signaling in the negotiation process is when both parties let it be known that they are ready to move forward with their position. Show the other party that you are ready to move forward, wait for the signal and move toward concession. After those 5 steps, you can start the package. And the package will help you to negotiate. In finalizing the test, which can be as an agreement between the parties. I think those steps can be done if those parties are in the best mood with the one who is leading, one who is doing the negotiation. And he has to be very professional and very neutral as possible in order to avoid all of the personal interests to get solution. That's my own idea.
Thank you very much, Modest, for that. Now we go back to Dr. Habimana. And when it comes to giving a pitch, how do you tailor make your delivery for virtual audiences, like the one we are in right now, versus in-person presentations, while still maintaining engagement and having the same impact?
Thank you, Elizabeth. Yeah, that's indeed very relevant, because today we are living in a world which is mainly driven by technology, where it's no more necessary to waste time traveling, engaging in unnecessary travels, when things can be done while we're still sitting where we are. So the same applies in the context of business and corporate matters. And substantively, there is no big difference. The difference is about the procedures and mainly the procedures, because what is needed is just to make an adjustment in terms of communication style, in terms of engagement techniques, in terms of maintaining the presence, impact, etc. So it's a matter of adjusting from an in-person setting to a virtual setting. Because like when I'm talking about adjusting communication style, let's say when we are in a person setting, you can use your entire body. You can use your body language, and any part of your body can be used. You can use your head, you can use your hand, you can use your arms, you can even use your legs. That is in person. But when it is in a virtual setting, you can only use your head and your hands, nothing else. So it's a matter of adjusting from using some parts of your body compared to when an in-person setting, you can use your entire body. So then again, in a virtual setting, people can be distracted compared to an in-person setting. And when you want to engage with your audience, in in-person setting, it is easy. You can even read the body language of your participants and your audience, then you can understand the message that is being sent to you. But in a virtual setting, you don't know who is there, you don't know who is active, you don't know who is sleeping. So right now we have more than 100, but probably some have signed on, and so we don't know. So when you want to interact with your audience, you may use, of course, some functions like chat functions, like pause, etc. But understandably, it's not the same like in an in-person setting. Same for the voice. When you're in an in-person setting, we are talking about negotiating, etc. At a given point of negotiation, you can pause strategically so that the audience can digest the argument that you've been presenting. So that can be possible in an in-person setting. But when it is a virtual, you may pause and people may think probably you have gone, probably your internet connectivity is having issues, etc. So, so pausing is not advisable in a virtual setting. But again, what you can do, like for me, when I'm teaching online, I like calling the names of my students and say, Mr. X, what's your view? Mr. X, can you respond? Mr. X, are you there? So that people can say, if this time is Mr. X, probably next will be me. So people can stay attentive just because they may think that anytime their name can be called upon to intervene. So then you also have to make sure that your setting is convenient, you're having a stable internet connectivity, you're having good microphone of your devices, etc. So, and overall is that in psychology, they say that a virtual setting, it is disturbing compared to an in-person setting. So it is always advisable to limit the time for a virtual setting. If you think your session in an in-person setting can have 5 hours, you can't have that in a virtual setting. You better cut it by half and maybe plan it for 2 hours, maximum 3 hours. So in brief, it's a matter of adjusting what we do in the person setting and they have it adjusted so that it can accommodate the requirements of a virtual setting. But substantively, the matters remain the same.
Thank you very much for that, Dr. Habimana. Again, I'd like to encourage the participants to keep interacting with us in the chat box and also ask questions, whether in the chat box or in the Q&A section. We're going to deal with that at the tail end of this session. Now, Mr. Sunday, when it comes to drafting contracts, something that we've had a lot recently is with regards to the advent of technology and its inclusion in contract drafting. Now, what is the role of emerging technology such as AI in contract drafting? And most importantly, what risks should we as lawyers be aware of when it comes to incorporating AI in that role?
Thank you, Elizabeth. So emerging technologies and AI in particular, I believe they are unavoidable, and they've started to shape, or they are reshaping the aspects of contract drafting, especially for us as lawyers, and their practice, even in Tanzania, as well as globally, is becoming more like imminent. We can't stay without. You can run from technology, you can run away from AI. So, and in my practice and in my department, I had the IP and tech department at Riven Core in Tanzania. We tend to deal with this a lot in terms of how we deal with our, especially, for most of the team members, you see that most of them are Gen Zs, or they are pro in terms of technology, so they would at some point or not use AI. And we use AI even in our tools in terms of how we look at a contract, in terms of how we analyze a contract and all those things. So you would see that, for example, the evolving in the role of AI and technology, that is, when it comes to initial drafting of or generating clauses, they suggest, so you have AI tools that include, let's say, general learning or large models like Google Gemini, OpenAI, ChatGPT, and there's Cloud, which can assist in like generating initial draft for common clauses and contracts. And they suggest that you can use, but you have to use like a specific prompt. So for example, one might ask a Gemini to outline the basic distribution agreement suitable for a Tanzanian maybe SMEs, and it does that for you. But you have to look at advanced contract review as well. So you have what you call specialized legal AI platforms such as Kira systems. We have Luminance, you have Evisort, and the like. They are more designed to help you scan, for example, analyze contract, and also help you to identify missing clauses, inconsistencies as well, potential risk of languages and deviating from maybe the firm's templates or playbooks. So this is particularly useful in due diligence exercises in law firms when you involve large volumes of documents, but also enhance the legal research. So AI-powered legal research platforms like Nexus, there is like Africa AI, they have Lex Justus, which can speed up the process of finding relevant legal and international cases. Relevant local and international cases, statutes, and legal purposes. So platforms like case law, we have in Africa jurisdiction at the moment. I believe case law can do that. It has been designed in a way that it can actually search for African judgments. So automation and repetitive tasks as well, that's an issue for tools like, let's say, Gavo, which have features which have comprehensive contract review lifecycle management, so CLM systems, such as Ironclad and Contract Pod AI, which can automate routine tasks by populating like party details, dates, standard clauses, and things like that. And then you have specialized drafting assistants, which they have tools like Spellbox, which now can integrate AI capabilities into, let's say, a word processing environment that can offer real-time drafting and reading, red line assistance and stuff like that. So I feel also like there's that risk as well for lawyers, even Tanzania, for like over-reliance, where it is crucial to understand that AI is an assistant, is a tool. It's not like a substitute for a qualified legal judgment, at least as of now. So we need to do that. So critical oversight, reviewing, verifying, adapting to AI-generated content. You need to ensure it aligns with the specific matter, client instructions, and the law as well, even our law contract, and then the relevant sector-specific legislation. So the professional responsibility always remains with us as lawyers, but accuracy, readability, thus AI hallucination, AI models can at times generate incorrect information or non-existent legal precedents or draft codes that actually they're inappropriate within the, let's say, the legal framework or in the commercial context, or they are unenforceable. So I would say also there's potential for bias. So AI algorithms, at times they learn from the data that are trained on. And if that data contains inherent bias, or AI may perpetuate something that is not actually correct. And then the global AI tools may not be adequate for, like, say, Tanzania, Uganda, Kenya. They're not trained for specifically for our legal precedent or commercial practices. So that's important, but also on confidentiality and data security. So it's very imperative when you're uploading sensitive documents, for example, two of the clients on these tools, especially those are also international, can raise data security concerns. In Tanzania, we have what we call the Personal Data Protection Act of 2022, which we have to subscribe to when you are doing these things. So we have to ensure that the AI tools that we use are compliant. And then also we have to look at the aspect of how we can have that contextual understanding. So, AI struggle a lot in like commercial realities of things, how we negotiate. So like the culture, the unspoken things that are not actually sent, but it's when you are doing eye to eye. So those persuasive advisory elements of, let's say, a role that we have as human beings will still be there, but also ethical. So as members, let's say, of Tanganyika Law Society, East Africa Law Society, we are bound by ethical duty of competence, diligence, confidentiality, all those things of which AI now without proper verification becomes an issue. There's a risk also for costs, accessibility, infrastructure challenges where accessing these tools can be costly, and which now relying on like stable high-speed internet for most of East African countries becomes an issue. I've seen that in Uganda. So challenges for some practitioners, that can be also an issue. So how we do that And then there's like an aspect of evolving regulatory framework where the regulation of AI is still there. So still there are discussions in Tanzania. We have the policy, but still, so Tanzania lawyer, for example, you need to be very informed. East African lawyers be very informed. But there's a risk of skill as well. That's a concern I always talk about, where you rely so much on drafting on AI, particularly for junior lawyers who need to impede on they can impede on their core legal drafting skills and ethical skills. So I believe we need to be very, very careful in how we use these language learning models, how we use AI, how we integrate in our day-to-day lives as lawyers, as practitioners. They come with those risks of which I think we are better off. I'm not saying we shouldn't use, we need to use, but it has to be calculated risks because we don't even have laws that would protect us in terms of in case of any violations, in case of any misuse in the future. So I'll end up there and then give it back to you to carry on. Thank you, Elizabeth.
Thank you very much, Sandy, for that. And thank you for emphasizing that AI is basically an assistant. All these models are assistants, and they're not the ones supposed to actually give the ultimate product to the client. And now we'll go on to Miss Asmahani. We had initially talked about negotiating assertively, but now we're going to talk about the role of empathy. Is there any role of empathy, or as legal practitioners or arbitrators, can we incorporate empathy into negotiations without appearing weak or giving too much ground to the other party? How do we do this?
Thank you, Elizabeth. Yes, just to answer that question, how you posed it, yes, there is room for empathy. Empathy, it's what connects us, it's what makes us human, it's a form of emotional intelligence. And so as lawyers, we need to have that. If I know sometimes it's like I say, depending on your training, depending on your mindset, depending on your just you, even your own personality can affect your ability to demonstrate empathy. But really empathy in brief is just you putting yourself in the other person's shoes, you trying to understand their point of view. So that is something very, very valuable when it comes to negotiations. And empathy is really at the center of creating win-win situations in even out of legal world, generally. So yeah, it's very important. Empathy is not a sign of weakness. It's just a form of accepting or knowing that the other person also has something to contribute to this negotiation, transaction, conversation, whatever it is. It is you understanding that you're dealing with a person, human beings in whatever form. We are emotional beings, we have feelings. Someone can come in for a negotiation, and I'll give an example. I was in a middle of a transaction, and then the other party gets a message. I think it was a message or WhatsApp, I don't remember. And I think their child or someone very close to them had gotten an accident or something. It was something really, but at that moment, we could have chosen, because this was right in the middle of it. We had really moved some miles. But empathy demands that you acknowledge that, you acknowledge that. It's not about, ending or, signing the transaction, let's move. You acknowledge that. You allow the person to express what they're feeling, and you give them a chance to say, okay, how would you want us to proceed? Do you want us to pause? Are you mentally okay? Do you feel that, and people who have embraced this kind of culture will tell you, they'll be like, you know what, this is too much for me. Let's pause. We can pick it up tomorrow or what, and it's okay. It doesn't mean that I'm being weak. It doesn't mean that it will make me a lesser, negotiator. No, it just means that I am acknowledging and understanding that the person seated right the other side is also a human being. So for me, I would really advocate for a change in mindset to be the humans who understand that we are all humans first, to always have the win-win scenario. You can't believe how many successful transactions you can close with that kind of mindset. You can't believe how much you can save your client, in terms of not just, I know litigation costs, we benefit from it sometimes, but I think it was Dr. Payo who talked about the strategic value you bring to your client. I don't benefit anything to have my client spend 10 years in court over a simple contractual matter. Yet we can sit down and have a win-win scenario. Win some, lose some, win some, lose some, and allow my client to go and do his business. We live in a very volatile world. So the more you reduce the disruptions in someone's business, or even us as business people in farms, or you as a practicing lawyer, the better. So you can focus on other things. So for me, I believe it's a mode of emotional intelligence, and one of the skills for this century. The World Economic Forum put out a study, and in the next perhaps maybe 10 years or so, the skills as we know them, what people are looking for as we know it now, it's totally changing. And top of the list was things like emotional intelligence. There was nothing like how best you can go and assert yourself and bully everyone out. No. It was emotional intelligence, because we are so much in this machine, daily world. Man, the people who will stand out are the people now who can connect or reconnect to human beings, because that is now an actual emerging need, that there is need for people to continuously connect and build relationships for this world to survive. So yes and yes, empathy does not make you weak. Empathy is actually a distinctive skill that we can build and use very well in terms of managing ourselves and our businesses. Thank you. Back to
Thank you very much for that. And thanks for emphasizing that empathy is a good skill that we should embrace. I've seen somebody saying that you've changed them into a calm lawyer today. I guess that's a good take home from this session. We can go on still on negotiations. We can go on to Mr. Modest. And now on the other side, when you're handling counterparties who are aggressive or who are uncooperative and highly strategic, how do you, or what steps, or what would you put in place to ensure that the balance of power is still there in as much as these counterparties are aggressive or uncooperative?
Many thanks, Elizabeth. I can advise all of the followers and all of the lawyers to use festivally the bodying language. The bodying language is the main strategy to succeed the negotiation. When you have got a good mood, the good way to talk to each other, to each party, you will succeed the negotiation. Many people want and need to be in front of someone who can listen them without cutting their ideas, and they have to hope and to believe in that person, to avoid the judge, to avoid the court. That's why the negotiation is among an alternative dispute resolution. And for those who are using that alternative dispute resolution, they have to perfect their body language. That's the advice I can give to each other.
Yes, it is important to remain calm despite facing an aggressive counterparty. Right, so once again, we go back to Dr. Habimana. But before we do so, again, I'd like to encourage all of you to keep interacting in the chat box and to ask questions, because we're just about to get into the Q&A section of this session. But we'll have one more round of questions and then we'll get into that. I'll address the questions in the chat box. Right, so Dr. Habimana, in instances where you have a pitch or a negotiation that's gone wrong, how can you quickly bounce back from that? And how can you use this experience constructively, both in that particular pitch or in future negotiations?
Thank you, Elizabeth. If it has gone wrong, I not be far from what has been said by Modest. Stay calm and understand that failing is a part of life. And by the failing is an opportunity to learn. So instead of just engaging in panic, stay calm. And if there is an opportunity to do it again, if there is an opportunity to correct the mistake done, please do. But before you make correction, you first of all need to understand what has been the cause of having things going wrong. So the starting point is to sit down and conduct a kind of diagnosis, strategic diagnosis, so that you can understand what are the causes. Then if it's not possible to reverse the situation, at least you can learn from that. Indeed, the problem we human beings, not necessarily lawyers, we human beings in general, is that we don't like failures. And because of not liking failures, sometimes we are tempted of not trying new things. Sometimes you don't want to engage just because we fear to fail. Yet without engaging, without attempting, without trying, it will not be possible to do good things. So we need to take failure as our friend, not failure as our enemy. And if you go through the histories of all successful people, all of them, what they have in common is that at a given time, they have failed. That is a common for all successful people. So same in any process, in any setting, in any transaction, to succeed, it may happen that at a given time you fail, but that is not the end of the story. That can be taken at the start of the story, because that failure, if translated into a learning session, it is paving the way for the future transactions. So basically, don't fear failures. Take failure as friends, not as enemies. Yeah.
Right, thank you very much for that. We should take failure as friends, not as enemies. Now, Mr. Sunday, when you're dealing with cross-border deals, how do you adapt a contract to meet the legal and commercial expectations of different jurisdictions?
Sorry, I was trying to connect any issues. I'm audible.
Yes, you are.
Oh, brilliant. Yeah. So, in cross-border deals, in my experience, I believe in adaptation to these deals, you have to look, normally we'll go at the choice of law. So we look at that. So I believe which is very fundamental. And it's one of those clauses that are more often than not is heavily negotiated in terms of laws we use in and of which will govern that contract in terms of interpretation, and as well as its Hello?
Hello, we can still hear you.
I saw a message popping up. So I was, yeah, all right. So there's that. So to be quick, I believe there's choice of law, also jurisdiction, and the dispute is, I think it's crucial. You see on, or you look at where the dispute will be resolved. So whether it's court in specific country, let's say, are you using LICA or UNICITRO rules? So it's always better to consider, like in Tanzania, we have for foreign judgments enforceability, we have what's called the Reciprocal Enforcement of Foreign Judgments Act. And then we have the Arbitration Act of 2020, which now incorporates the UNICITRO model. So that the language that you use, I believe, so it has to be an authoritative language, which now you can specify the official language in the contract. Is it English? Is it something else? And if there are translation as well. So what's there, but also compliance to the mandatory local laws. That's very important. Like for Tanzania, we have the Fair Competition Act, or like I spoke of the Personal Data Protection Act. Also, you look into, let's say you are cutting for the national resources sector, which requires perhaps for local content requirements. So that also you need to consider. And then how you can navigate the commercial expectations, because they are mostly different in terms of the business practice that you have or the negotiation style, because culture also plays a critical role when you are negotiating. So even the pace also of the business, so that also can come into play because we are doing cross-border, and then there is sensitive issue that have to be considered. So the clear communication you are putting forward, the willingness as well to understand the other party in terms of their commercial culture, but also currency payments, tax implications also come into play in terms of how we do this. So what are the mechanisms that are going to be used to mitigate, for example, the exchange rate, the risks that are involved, the medium of methods of payment that are acceptable and legally within that jurisdiction or both jurisdiction. There are tax implication with audit tax VAT, like for Tanzania is different. Let's say if you're doing contract Tanzania, the VAT is mainland is 18%, in Zanzibar is 15%. So those have issues in terms of what you are getting yourself into. We have intellectual property rights as well to consider. Are you protected under copyright, trademarks, and the likes? What do you incorporate? Who gets to keep what, and all that stuff? So that also, because jurisdictional wise, that cuts across, because the international laws as far as IP is concerned also will come into play, because there could be you're doing trademarks, but then it was filed under a repo, or there are some who rely on PCT applications, and then you're not sure if there was actually they'd extended into now filing locally and stuff like that. So I'll say that, and the likes of execution formalities, the likes of doing a thorough due diligence on the foreign country counterpart legal standing, their financial stability, viability, their protection, and the like. So I would say, in a nutshell, those are the things that you probably have to consider.
Right. Thank you very much, Mr. Sunday, for that. Now, going back to negotiations, Miss Sad, I've seen a lot of comments in the chat box regarding fees and negotiating fees. What's your perspective on value-based pricing, and how is it changing the negotiation dynamic between lawyers and clients? Particularly, I've seen a lot of comments, especially this one from Justice Di Balema, who says negotiating fees is challenging and cumbersome, especially when dealing with someone who does not value your profession. So maybe tell us a bit about that.
All right, thank you, Elizabeth. FYI, I don't like negotiating fees as well. So, but it comes with our profession, it comes with our service, or it's one of those things we have to learn to do. Gone are the days when, I miss those days where you just send your billing proposal, your billing structure, and boom, it's done. But like I said, the dynamics have changed. There is a lot of free stuff out there for our clients. These days, I remember I had a client who came in and they were doing, it was actually a very complex transaction related to commodities. I will not mention the specific commodity, but they had kind of weaseled their way into making this contract, trying to put down an SPA. And what they wanted us to do is to just peruse through and advise them and then just sign, have that legal representation. And I had to sell value. Because literally I was like, I have my agreements, they're here. So what are you going to bill me for drafting an SPA? No, it's here. So it's a very good, I would say it's here and there. It's not a good place to be in. Honestly, like I said, I miss those days. I know some of you are young lawyers, so you have bumped into this sudden change, but it's a dynamic. 10 years before, maybe close to 10 years before, even when I just started legal practice, the big law firms we practiced in, or when I was an in-house counsel, you receive these billing structures and that's it. There's no negotiation. I'm going to charge you this per hour. If it's a retainer, these are my fees, and and that's it. So now your name is not enough. You can't say because I'm Katie Advocates, I'll throw you a bill of $10,000 and it will swing. It will not swing. So now meaning that clients are empowered. Okay, so we have to understand that, because if we come from that understanding, then we'll know what we are selling. Clients are empowered. Information is there. ChatGPT, all these AI tools we've talked about, all these contract templates Sandy has talked about, clients have access to those things. So now, if a client tells you I've done 70% of the work, what are you telling me? So now that's where we get into value-based pricing. So the question is, can you identify the value you are bringing to this client? Beyond drafting, beyond whatever he thinks that he has managed on his own, what else are you going to sell to this client? And I think I hinted on it before. Number one, what value are you bringing to this client? I've noticed now, and Dr. Pai hinted on this, clients want to know, clients have shifted to wanting to have partners, people to work. They might not say it, but they want to see that you also have a vested interest in whatever they are doing. It's not just about come tell me about these legal clauses and this and this, and you walk out of the room. I can get those on the internet. I'm fine. What else can you tell me about these things? Can I navigate the laws without breaking the laws? Can I navigate the intricacies around these laws and still survive as a business and make a business decision? Can I, or are you just going to say, section 15 of this thing, no, you cannot do this. No, we cannot do this. No, okay. ChatGPT can tell me all that. So what value are you bringing to the table? So now we must really have a mindset shift and know that as we have moved from being lawyers, we have moved from being business partners. Business partners. We have moved to being strategists. We have moved to being people of value. Like I talked about when I was talking about your networks, your social capital has also now moved into becoming part of your professional capital. If today I know, I mentioned we do a lot of market entry. If I know that there's a regulatory hindrance, more than ever, I need to call on that network. If I know Elizabeth is the one seated at the Uganda Communications Commission, and between me and my timeline, she is the one who is going to sort us out, I need to call up on that social capital. It could be my social capital. I don't need to share it with my client. The client knows the timelines. We have told you it will take us 30 days, 60 days, 90 days to get this license. But a lawyer who can pull out that license in a week or 5 days is the distinctive lawyer, is the value-based lawyer. So you find that now it's not enough. It's not enough. Client relationships. I'm so big on relationships because I realized these days clients will come to you because of their value, their relationship. Are you relating well? You know, these days now we even send clients, you know, hampers. You know, my female corporate clients, I always like to send them gift cards per day or what. A lawyer who has practiced law 20 or 30 years or even 10 years back, for those who are still practicing, they literally, they still cringe at these things like, why do I care if you're coming from a board meeting and you're tired? Why do I need to take you to a spa? But it's a relationship. We take out our clients, we sit, we hang out with them, you know, yes, it's business, but that is value. It's you're building a relationship, and people will give work to those they know, those who they can relate with, those who they can make a call. And beyond your service, you're not about, okay, before I answer this, can I first send you my billing hour? You know, I have, you know, company secretaries, because I sit on a board, so I have a very clear and a good understanding of how these things work. And someone will just call, is like, Asmani, I have this and this issue. How do I sort it out? I'm not going to first tell them, you know what, let me first tell you my billing per hour. No. Now they're calling on the relationship. So I need to move that hard. And I just relate with her as a colleague who has a question to ask me. And I'll give her a quick response then and then. And I don't have to sell her bill after that. So for me, that is value. That is value-based billing. When I build a relationship, then I know at one point in time, I will call on the relationship. For example, a client can come, and when you understand their needs and wants, some things might not be a priority to bring on the table now. If you feel that their pain point is you're too expensive, some things might come in later. But the more they work with you and relate with you and see the value they bring, later on, even if you throw in now your big bill, I've found that clients do not have a problem with that, because now you're trusted. They see the value that you bring to the table. They see that, okay, this person can open some doors that I'm sure I would not have gotten here without my lawyer. You see people presenting you in spaces. I mean, I've walked in rooms and someone with so much pride, they're like, this is my lawyer. If she doesn't say anything to, you know, someone gives you that that responsibility, you know, and they're like, I'm not going to make a decision, let my lawyer make that decision. So again, that for me, relationships are important in our practice today. The value, we need to distinctively identify those things that separate us from any other lawyer, that separate us with what our client can get from his accountant, can separate us from what our client can get from any other relationships that he has. So we position ourselves that way. Then lastly, I think also it's also important to know what is the worth that you're giving this client, you know. Some of us who have been in practice for long, you see that, and that's why these days I'm so keen with the way people respond, you know. It's no longer about your knowledge. People now look at your personality, your behavior. What are your socials looking like? Who are you? You know, I don't want a scandalous lawyer representing me as a bank. I don't want. You might be the most intelligent, you have all your legal knowledge, but who are you? Who are you out of this? So your worth, your credibility, what are people saying about you? You know, I've come to a full realization that people make decisions these days on things that you'd never have imagined years back, right? So as young lawyers, be very careful. You know, we are lawyers, we are advocates. There is something that people want to see in us, whether we like it or not. So the things you say out there, you know, think about it. You might be young now, maybe 2 years, 3 years into practice, but this is your bread and butter. This is your profession. Do you want those things to be the things that are separating you? Maybe this is a very high-end international lawyer or something, I mean, international company, and they have like 3 lawyers lined up. You could have gotten this job, but because 5 years or so, you talked something about this, and then they're like, no. I'm not going with this person. And just like that, you lose the opportunity. So let's expand value. Value is not just about money. Value has moved distinctively. And this is the journey we're walking. And I don't see it changing. I see it getting deeper and deeper. And so we just have to clearly identify, beyond my expertise, beyond what I want to bill you, how else can I sell myself to you? How else can I position myself in terms of the needs that you have, and you coming to me, or me coming to you? Because these days we do a lot of bidding, you know, We bid for jobs, someone doesn't see you, they're just seeing your documents. People go and refer to your socials. It's so funny how the world has the dynamics have really changed. So it's also reading into these pulses. We have to have that intuition, reading into the said and the unsaid, and working around there. Then billing, for sure, you get used to it, but also you're building on how much your worth can be. Yeah, so that's it, Elizabeth. Thank you.
Thank you very much for that. And now our last question to Modeste. How can law firms or organizations create supportive environments that foster resilience, especially amongst young or early career professionals? How can law firms, organizations create supportive environments to foster resilience amongst young advocates or early career professionals?
Many thanks, Elizabeth, for your question. I think the law firm has to be led by our bar association. Our bar association must lead our law firms before us organizing the training and updating the knowledge of our members. And if our bar association lead us, I think we can manage in each law firms to lead also and coach our members to be able to solution all of the problem which is exposed to them.
Thank you very much. We'll come back to you on that.
Okay.
And now we're getting straight into the Q&A section. I will identify certain questions and pitch them towards a particular panelist. And the first question that we'll deal with is from John Patrick Okoth, who says there's one thing that happens in negotiations, which is appealing to emotions, and this can go two ways. First, when a negotiator is good at his or her pitch, they can paint a picture that's so vivid that the protagonist gets swept away and buys into the negotiated deal. Then there's that poor negotiator who goes into a pitch without preparation with only one pitch idea and who will resort to becoming aggressive and sometimes abusive, thus losing the client altogether. So this brings me to the question, are good negotiation skills nurtured, taught, or are they part of our nature? I'll address this, or I'll ask Dr. Habimana to address this question.
Yeah, thank you, Elizabeth. This is a very good question, and if you're a lawyer in front of that situation, you have to celebrate, because that is an opportunity for you to prove who you are, to show what you can. Otherwise, I don't think that just walking in a clean way is a good way, or you cannot show up yourself as a good lawyer if you're always walking just in a clean way. But if you can walk in a forest alone and go through lions and all kinds of animals in the forest, and you get out of that forest, so that's where you can claim yourself to be a hero. So the same, this is common. It is common. When you are negotiating, you can come across with different kinds of negotiators, etc. So there is no single answer to how to behave, because it all depends on that specific session that you are in. So depending on how the situation is, you have to think of some strategies that you can put forward so that you can get out as a winner. So whether negotiation skills we are born with, whether we can be taught negotiation skills, in my belief, I believe that a person, a human being, has a capacity to learn anything as long as he or she is interested. So I can't believe there is a person who is born as a good negotiator or a person who is born as a bad negotiator. I don't believe so. It's all about how the society has taught us to behave, either as bad or as a good negotiator. Because what we are, it is a result of the society that we've been living in. So I think we have that capacity to leverage what we have, but of course, to learn something new, we need to take aside what you have learned. So that is a problem which is not only for this negotiation. This world we are living in, we are taught several things which are not true, which are wrong, which are about biases, etc. And because we learned those things when we are still small children, when you grow up, now, after discovering that what has been taught to us was wrong, it takes us time, first of all, to put out what, I don't know if it is a kind of poison, to put out that poison so that we can eat a healthy food. But it's possible, as long as there is a will, as long as a person wants to do so, I think it's possible. So lawyers, I like saying, handling a complex transaction, I like it than handling a simple transaction, because that is an opportunity to show who I am, to prove what I can do. Because I don't like doing things that can be done by any person. No. I like doing things that can be done by few persons, and among those few persons, I must be the one of those few persons who can handle those complex transactions, including coming across a situation where there is a conflict between what your client wants against the principles taught to you in a school or in the other practices, etc. So, Elizabeth, that's how I can answer that question.
Yes, thank you very much for that. Yes, more complex transactions make us stand out and give us more of a challenge. Now, in less than a minute, Mr. Sunday, Elizabeth Olau is asking, on drafting a contract, how do you deal with clients who want the dispute resolution clause, who don't want the dispute resolution clause, sorry, in the contract because they're diplomats? So how do you deal with such clients who don't want a dispute resolution clause?
Thank you very much. So yes, I agree. It's very tricky, but as a lawyer, I say my concern would be to protect my client's interests. So, but then you have to respect international law and diplomatic status. So you need to understand, I'll say two things, one or three, maybe the diplomatic immunity. So the Vienna Convention on Diplomatic Relations gives them or grants diplomats certain immunities from jurisdictions, especially of the receiving state's courts. So that immunity, it's very vital for them, and they consider that as much, and they would want their lawyer to understand that. So there is that, but also there is what we call sovereign immunity, of which now that also it gives, even though a diplomat is an individual, but they are connected to their state. And now the state themselves generally involve that they want to enjoy the immunity from the issue of foreign costs. So although the immunity has exceptions, but especially on particularly on commercial activities, that is a consideration. But also the enforceability of it. When they come and they're diplomats, they look at so the standard dispute resolution clause. It has to, is it providing for jurisdiction, for example, in a specific court? The practicability of its enforceability is questionable against a diplomat, for example, who enjoys now, or they want to invoke their immunity as per the convention. So there is that. And then there is a waiver of immunity, of which now that waiver you can't do away with yourself as a diplomat, but you are, so to speak, your state can. So but so it cannot be you say done unilateral. So there's that, but I would say perhaps when the alternative dispute resolution should perhaps become also an alternative to a dispute resolution clause. So mediation and arbitration, and there are ways of which you can draft them in a way that could actually perhaps become enforceable depending on the circumstances, whether it's the new convention or recognition of enforceable for foreign awards or not. So that could be. So I would say, first of all, you need to understand. They need to understand that you understand the scope of their immunity, and then you can prioritize on their amicable resolutions. But also, they would want to know if you have, perhaps you could say that there are other options that you can do in terms of ADR and how you can draft a tailored clause to cater for that. So I would say basically that, and that's in scenarios that I've come across, I would do that. And I would suggest now a clause that would cater for that. So it would go in terms of making perhaps, let's say, a neutral jurisdiction, of which, yes, it would cater for relevant convention, or like the Vienna Convention has to be in there as well. But you draft it in a way that parties will be able to agree for arbitral proceedings, for example, to be interpreted as a waiver as well of such immunity that is there. So I have 1 minute. So in 1 minute, I would say that's that. I know we're out of time. I could have, yes, but I believe that would narrate it that way. So that's how I would have ended it.
Right. So again, we're out of time. Thank you very much, Sandy. We have a few more questions, but because of time, we can't deal with them. But maybe our panelists would be willing to address those questions, maybe on LinkedIn or something. The attendees may be able to contact them there. Is that okay, I guess, with everyone?
Yeah, that's okay. That's okay. I saw the one on copyright I wanted to respond to, but that's fine. Perhaps some other time.
Yes. We probably need more time to deal with more of the questions. We have 4 more questions that we've not dealt with. But once again, thank you so much, all of you, for participating in this panel discussion. Thank you for giving us your time and for your active engagement throughout today's session. We've learned a lot. Personally, I have. It's been a truly enriching discussion, highlighting key strategies and tools for navigating complex negotiations, pitches, and negotiations. And we appreciate all of your time and effort, and we hope that this session has packed ideas and tools for all the participants to use in enhancing their own practice professionally. I'd like to hand the session back to Mr. Achai to take over from there.
Yeah, thank you so much, Ms. Musikali, and our dear esteemed panelists for this very wonderful session. I would like to thank you on behalf of the Secretariat of the East Africa Law Society for your dedication, preparation, and very smart execution of this session. It's not only been a learning experience, but it's been one of acquisition of hands-on knowledge passed to us by our seniors who have been in this field for long. Thank you so much, Liz, for steering a very wonderful conversation. And to you, Dr. P, Mr. Ndamgoba, Mrs. Mahani, and Mr. Modest Mulumba for that very wonderful nuggets of wisdom that you've shared. This brings the close of this session. On Thursday, we'll have a session on dispute resolution in sports law. So you want to be on the lookout for that. And please, if you want to know more about our events, visit us at our website, www.elawsociety.org. And also to let you know that in the month of June, we'll be having our legal and legislative drafting workshop happening from the 3rd to the 6th of June, right here in Arusha, Tanzania. So we urge you to visit our website and sign up for that training session. But that coming from us, we wish you a very lovely afternoon. You stay blessed until we meet again. Goodbye. You can now exit at will. Thank you.
Bye.
Thank you.